Hello friends, welcome to the channel All in One for You. First of all, subscribe my channel for more English and Punjabi shorthand dictations. Today I am going to dictate you approximate 400 words with 80 word per minute speed dictation. So be ready, let's start.
The learned judge fell into error of law in observing that he cannot look into the affidavit at all full stop. There is also a valid reason for non-attendance of the respondent in the court full stop. In the circumstances, the order of the lower court is set aside and the appeal is allowed full stop. We declare that the marriage between the parties shall stand dissolved with effect from the date of this judgment and a decree for divorce be passed full stop. We make no order as to costs full stop. Next para. This court in civil revision number 3648 of 2007 titled as Suraj Kumar Verma Gunita Verma decided on 15/10/2007 had set aside the order passed by the learned court below directing the parties to be present in person while permitting him to be represented by his attorney, further considering the fact that the husband in that case was abroad and could not appear in person full stop. Section 21 of the Hindu Marriage Act provides that as far as may be the proceedings under the act are to be regulated by the CPC full stop. Order 3 of the CPC provides for appearance of the parties through the recognized agent or a pleader full stop. The recognized agent may be a person holding power of attorney authorizing him to make and do such appearances, applications, and acts on behalf of such parties full stop. Next para. Section 23(1)(b) of the Act provides that in proceedings under the Act, whether defendant or not, the court has to be satisfied, especially in the cases where the divorce is sought on the ground of mutual consent, that such consent has not been obtained by force, fraud, or undue influence full stop. Next para. In the present case, it is not disputed that the father of the husband respondent is holding a valid power of attorney executed by his son, the husband, to appear on his behalf and take all steps for filing a petition for divorce by mutual consent and getting the statements recorded on his behalf full stop. The genuineness of the power of attorney has not been doubted. It has not been pointed out before me that the learned court below had ever directed the respondent husband to be present in person for being satisfied of the facts stated in the petition or the statement made by the father of the respondent as his attorney, doubting the genuineness of the compromise or otherwise for any good reason full stop. Next para. A perusal of the impugned judgment of the learned court below shows that the learned court below dismissed the petition on the ground that the parties had not appeared in person, it had not recorded any finding as regards the petition being not bona fide, or that the averments made in the petition were not true and correct, and further that the consent of either of the parties had been obtained by force, fraud, or undue influence, which was sine qua non for consideration of a petition for divorce by way of mutual consent. Full stop.